Good day, good rising, Quinn. What? Saturday, your gift from me, Famalan, the 12th of October 2019 CE. May I just say,
Who loves you and who do you love? Without further ado, it's time to start running.
oh,
Who loves you and who do you love? Without further ado, it's time to start running.
that's right, you're all accused of being in league with the devil. Who do you love and who loves you? Do you remember the Messiah? Did I dream that you dreamed about me? Did I dream? Temple of Dreams or something, Messiah? Anunnaki, world order, stemming from Romans and the Numa Elish. My head is about there today. I've got a presentation for you about secret and half secret trusts. I've done a little bit of posting after my 6.5 hours rest last night on the .com and onto the Book of Faces. And we're going to talk and discuss secret and half secret trusts. If you've got any knowledge, I'd like to know what your knowledge is. I'm going to go through the areas of equity and trust. So I get asked a lot of questions and I don't know how to answer them on the spot. What I am doing is making references to situations in law in trusts and equity, and there are such a thing as a secret trust. There are trust documents, deeds, and expressions. These are legal instruments, all right? So they do involve persons. When God is not a respecter of person, then we would argue that persons and trusts are not quite honourable to go in. That's right. So David is the Christian part of the part of God's trust covenant, original man, and I respect that. I'm in that. That's not legal. That's not persons. That's man. That's covenant. And that's where I am. That's where I come to you here today from. But what I'm going to bring to you is England and Wales trusts, which involved persons and their legal instruments. And there are other types of trust as you will go through this journey. I am taking a couple through a journey now that have asked me to give. I'm very honoured and humble about this, to take them on a trip, a journey. The poison is out there. They want the remedy, much like the prodigy and our Keith. All right, I believe we have the remedy for that poison in some, deeper way where you will find the devil in the details. So please bear with. You're going to get some feedback from these two. I've asked them to consider the interaction, how we go, the outlay of information, how they get it, what goes on in Babylon. Here we go. So we're going to call this section now secret and half secret trusts. The secret and half secret trusts do not accordingly, all right, meet the formalities set out in section 9 of the Wills Act 1837. This is why I'm here to answer this. As we go through it, you will soon see why I'm doing this, and hopefully pennies will drop. So the question naturally comes to mind: why do the courts enforce these types of trusts? What trusts did you say? I said secret and half secret trusts. I think it may basically come down to two things, fam. Firstly, equity. All right, here we go. Has an interesting part of it. It does delights in seeing justice and fairness being done. Equity is it means fairness, equal. All right, to be equal. So secondly, the courts, they're very interested in not allowing fraud. Hear me out, sorry, but to be perpetrated. Put barratry and personage and non-disclosure and fiduciary duties, and the non-disclosed contracts of admiralty and whatnot in a vessel in the dry dock masquerading as, and just hear me out. So the courts are very interested, higher courts and courts of equity, especially here, interested in not allowing fraud to be perpetrated. So there's a little bit of background on secrets and half secret trusts before we make the splash down and we walk off the plank and we take this swim into the ocean and the currency of secret trusts. So I will give you the few principles that would underpin the secret and a half secret trust. They're relatively simple and revolve in the first instance around a testator, or somebody who is creating a will to decide what happens to their property after they die. And for whatever reason, the testator wants to pass on part of their property to a person who cannot, and will not be named. What? That's right, fam. Why wouldn't you name the beneficiary, the person, the legal, instrument of the property who it's intended for? The reason why they cannot be named, I'm sorry, ladies, but here we go in this male, stale and pale environment. Here we go. It's normally in the case law based around men who are creating a will, and they have a mistress, other insignificant half that they are, being unfaithful and breaking the covenant of man and wife with, and they probably have an illegitimate child. We look at the, aristocracy, and we look at the elect leaders of the public, civil, secular, and wow, some of them say they're women and they were previously men, it seems. So there's a lot going on here in this secret trust area. But ladies, I'm sorry, men, we're not all this way. I know I've met a lot of you good men, and you would never do this. But there's a mistress, there's an illegitimate child, and they want to give some of their property to this family here that's unofficial. They've got going on in secret, non-disclosed. Yes, indeed. So without letting their actually family know about it, they want to transfer assets, property, titles after the death. So how do they actually go about doing this? Well, what type of trust would this be, David? Well, here we go. This is going to tell you about equity. You're going to learn something here, I do hope. The cognizance should be fantastic. Have we got anybody in? We have indeed, other than Quinn. I saw Fly, Jerry. All right, I'm on flight mode, so you can text away. I'll pick it up when the aeroplane comes off the phone. Aeroplane's on phone. Life is good. All is blessed. No stress. Yes, my fam. I have forgot to get a drink, so if you will bear with me, just literally a minute. Get a pen and paper. Get a comfy chair. We're going to go into 5 pages, a mere 2,000 words for me. Nothing really for your Saturday gift. Uno momento, por favor. The chalice. There she blows. Okay. Thank you for joining me. Thank you for your time. Those of you that are interested in learning trust, equity, ears up, eyes down. All right. Essentially, a testator can pass the property through the will to an intermediary, and then this intermediary acts as a secret trustee. The secret trustee will hold property and for the benefit of the person who cannot be named, or persons. So essentially, they're using a middleman between the testator and the persons who cannot be named. So what's the difference between a secret trust and a half-secret trust? Well, here we go. From what I've seen and my discovery, this is not legal advice, and this is, pioneering, cutting edge, somewhat deep state secrets, so bear with me. Secret trusts, as their property called, are not mentioned at all in the will, all right? Secret trusts, yeah. Secret trusts, as they're properly called, are not mentioned at all in the will, all right? The testator's will. It's a fully secret trust. And a half secret trust will is actually mentioned in the will, the last will and testament by the testator, but the details of the terms of the trust are not going to be gone into in detail, all right? But in the half secret trust, it will be mentioned in the will, and the details are going to be quite ambiguous. So that's what I've found. If you know anything different, hit me up. I'd like your comments. So it will be, and there will be an awareness within the will that there is a sort of secret trust going on, but none of the details will actually be included in the will. You get me, fam? Do you follow? Are you with me? So how do we establish a secret trust, David? Okay then, from what I've found and what I see and what's come to light and going through case law, I'm going to name drop. You're going to get some clangers. All right, so get your pens down. This is where you need to make note. We're going to start with a secret trust, although the requirements, as I see it, are essentially the same for a half-secret trust as well. For secret trust, we've got the case of Ottaway and Norman, 1972. That was a bonny 6 years before I entered the realm my soul was in. Well done, thank you. They were preparing before I arrived. It's going to establish three things that we need to look for as part of our secret trust, okay? I've told you the three certainties of a trust, the three C's. That would be the intention to benefit the person that cannot be named, the communication of that intention from the testator to the secret intermediary trustee, and then the acceptance by the secret trustee of the trust obligation. So let's go through each three of these points in turn, slowly, calmly, methodically, and you ask me your questions as they arise, and then I will go back after, and I will go back, and you can have your answers and be duly informed. I'll go through each three of these points, which would be the intention, communication, and acceptance in a secret trust, because this is going to be kind of upper, higher level knowledge here, all right? You don't learn this on day one, let me tell you. I'm going to look at the intention, and very simply, the intention has to be to impose a trust obligation rather than a mere moral obligation. The case law that comes from McCormick and Grogan, 1869, McCormick and Grogan. I am going to publish this document along with the others on the .com, and it's going to go with the other trust 100-page document. This is a little soupçon before we put fin at the end. I'm not content with 100. I want to go to 105. I was going to go to 113 and make it symbolic and send that hurrah back up to the divine consciousness with the fun it's had with me, with the alchemic number correlation. So McCormick and Grogan, 1869 case law, all right, is going to be where this comes from. And essentially what we're going to be talking about is the moral obligation. With a moral obligation is if I said I give £10,000 to David because he will know what the right thing to do with it is. Saying what the right thing to do is more of a moral obligation, okay, just by mentioning that. Whereas if I said I give £10,000 to David for the purposes set out in a letter to him that I've given and he's received, it's been given, we can prove that you've given me a letter on the 8th of December 2017, let's say, then as we've done that, it's going to be fairly obvious to David that there is the establishment of the reference to a secret trust. I've chosen them words very carefully, which I maybe mentioned to him in a letter on that date. And secondly, we have to look at the requirement of communication, and this can be written or an oral communication, but as I said to you yesterday, orals quite sketchy and cause a bit of controversy. It has to include not only the intention to establish the secret trust, but also any relevant terms of that secret trust as well, okay? Communication, this is the Hermetic principles, and I'm seeing in trust, right, they've used the Hermetic principality, which is what makes me so Anunnaki, Anu world order, Anu Romans, and washing your hands, clean hands, killing of the Jesus there, Pontius Pilate scheme, and the titles for this rather scattered, but if you've been watching me, you'll hopefully get this. The relevant terms in this are going to be things like who are the beneficiaries of the secret trust and what is the property that is going to be established. Now, the importance of the certainty of subject matter, i.e. what is the property, that's really important. And in the case of Colin Cooper, we had a trust of about, I think, £5,000, and then the testator tried to add to that, afterwards. And unfortunately, they did not seem to properly communicate. They were adding to the trust fund with the, secret trustee. They didn't know that the trust fund was going to be added to. The secret trustee did not know from the testator that there was going to be any more than £5,000, 5 large in that account. So when they tried to make it more than £5,000, because there'd been a failure, the communication had fallen down to the secret trustee effectively. It was only the original £5,000 that remained part of the secret trust. So all of the terms do have to be communicated, and this stuff has happened in a court, all right? I haven't made it up. I'm not lying to you. This is real, all right? 1800 business, big man things, all right? I've got to go a bit deeper, so bear with me. We haven't gone as deep as we need to. We're going deeper, all right? So bear with. In terms of the timing of that communication, and communication, it has to take place prior to the death of the testator. That is essential and key. This case law was established in Moss versus Cooper, 1861. It appears Matthew in Sheffield said between the 1850s and the 1800s and the 1950s, there was a massive 150 year of excellence in law, in science, in development. And at the 1950s, 1940s, we'll say, you know where I'm coming from, things changed. And here we are, 70 something years on, 70 years of communism being celebrated over, in the Asian Pacific. So I'm doing this for a reason. Exit Babylon, no fighting, no blood, no war, logic and intelligence, testators. This case law, Moss versus Cooper, 1861. Check that. All right, fam. I see Shadow and John and everybody making notes in my mind mentally. I see you scribbling. It's energizing me, even though I can't physically see you do it. Finally, we have acceptance. All right, and that can be expressed or implied. IMP. Implied. This is the technology we're talking about. I tell you, I'm not happy. I see it. It shouts at me, and there's more to come. All right, we're going deeper than this later on in the silver and gold levels of your key competence. So, patience, slowly, catchy, monkey, magic. So we're going to look at acceptance, and it can be expressed or implied. And one of the classic cases in secret trust is Walgrave versus Tebbs, 1855. I told you I'm name dropping. Clang. All right, here we have Tebbs being given 12,000 bags of sand, and as part of a will, it was later found through various forms of written and oral evidences that there was an intention to create a secret trust. But Tebbs had never been informed about this and was not aware of it. And so, because there hadn't been any communication, listen up, our ears sharpen, it was obviously impossible for Tebbs to accept the secret trust. So that failed, and in that particular case, Tebbs, I've put tabs there, see, was able to hold on to the 12 large. So it can go wrong. You try and set this up and you do it wrong, then the ones that you give it to, the trustee, they hold on to it and say, what trust? What do you mean, what trust? So 12 large, 5 grand, yeah? You get that? I'm not telling you to do this. This is just a chance. I'm giving you information. You're going to research it and we're going to expand on it later. You will be using this for your referencing in our key competence, silver and gold levels. New initiates, don't worry. This is advanced. Just enjoy the ride, hear me out and go with the flow. Can't beat the system, go with the flow. If you're looking for the attitude, go with the flow, top buzz. So there are 3 requirements, and as I said, for half secret trust, it's basically the same thing. The only thing to watch out for, in my opinion, humble opinion, with half secret trust, is that the time of the communication is a little bit different. So where it is secret, so with secret trust communication had to occur before the death of the testator. With half secret trust, because of the half secret trust is referred to within the will, the communication must occur before or at the time that the will is executed. Case law, more pens, all right, Lord Sumner, 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 in Blackwell versus Blackwell. When you see a name like that, Knight versus Knight, Blackwell versus Blackwell, Causa versus Causa, these are normally man versus wife, or family versus family, you know what I mean? And it's pretty much dirty. It's a real dirty fight. It's not pleasant. It causes heartache, upset. It really does cause massive problems. We have an issue I'm going to hypothetically bring up to you next, all right, about fraud. Now, anybody that's mentioned fraud, I'm with you. I'm not looking at the screen, but you have to be careful now, because when you have these secret trusts and you get somebody popping up who's a secret trustee, can you imagine what's going to go down? And you've got to go to a court and sort this out. Okay, then. So before we move on and discuss some of the issues around secrets and half secret trusts, one of the other ways that this sort of secret trust coming to being is also through, you may have heard me say it before, intestacy. Intestacy. I can say it, I'm just saying it different ways so you get it and you hear it. Intestacy. Intestacy, I've talked about this with courts and probate and estates and wills, and when you go in and how you go into the court when they've summoned the estate, you are in probate. So probates are to do with wills, probates are to do with court, state of standing capacity. Intestacy, I do struggle to say it because it doesn't seem natural phonically, but it's basically when you don't have a will, you haven't created one. As I've said, why it's important to have a last will and testament, so man hasn't got one in the first place. And when that happens, as we've pointed out hundreds of times to you now, there are certain rules about what will happen to a certain person's property that may not have made and shown that they have a will. A person may decide not to create it, well knowing that their property will pass, for example, to their only son. You may want that only son then to pass the property on to a person who they don't want to name. And so even though there isn't a trust physically in that situation in the world, there isn't a will that's being established. A secret trust can potentially arise out of intestacy. And if there has been that intention, communication, and acceptance, fam. What you saying? Listen to me, hear me, make notes, go slowly, rewind selector. You may need to watch this presentation twice. This is a mammoth Saturday video for you. I see the 13 on now. I dare say that this needs to be shared. All right, they are limiting my sharing capability. It's becoming extremely hard to get out what I need to get out, so I will pause a minute and say, if you're enjoying this and you're having moments of penny drops, then to give me help and to get you a boost from the universe and to give it the high five, if you've not high fived with the records and the divinity, the matrix, the phonics, the numbers, you want to say hello to what we deal with and our systems of the hermeticism and the principles of the universal, Pazio style, natural, ethereal, quantum science, then you share this and you will get a high five. I promise you. I will ask and I will kind of command, because all is mind and meant and atom. I will make it so. I will send out a sonic boom of whatever it is. If you press share, like, subscribe, hit me up, embed me, you will, I promise you, I put the intention in. I've got the certainty and I have the intent. They've copied this from somewhere, everybody. This isn't man's methodology. We found something and they've emulated it, much like the web and other things in life which work massively well when we emulate, much like the Atlanteans with nature. All right, so I'm not going to go too far off the road, but I need help. All right, I'm on point. We are very strong. We're about to expand. The fam needs help. This is a crossroads, and I'm sending out the sonic boom as we speak through all the dimensions on an ethereal divine network. All right, electromagneto. So thank you in advance. Continuing on. All right, we're going to go hardcore. All right. With the person, we'll get the money based on intestacy rules. You want to look at case law again? All right, I'll give you some more. Selak versus Harris, 1708. So what happens if the secret trust fails? Well, there's basically two possibilities here. I hear you say to me, I'm going to take back to you. The money can either simply go to the beneficiary, which is what happened in Walgrave versus Tebbs, or it can be a resulting trust. I'm so good to you, aren't I? I know I am. And to those that are shills and steal it, you're welcome to it. I don't want it. It's for you. I give it away knowingly. It can be resulting trust, so the money reverts back to the testator's estate. The remedy that is applied in this situation is basically dependent on the knowledge of the secret trustee. So if the secret trustee had absolutely no knowledge, nil, kaput, I know nothing whatsoever of the proposed trust, then danger, then that money will just go to them, okay? They'll keep it, you'll lose it, and they will be the rightful beneficiary, the trustee who's now the beneficiary. What? Exactly? I did not tell you to do this. I'm telling you what, go on, Babylon. So that would be property under the will. So that's what we saw in Walgrave and Tebbs. On the other hand, if the beneficiary did have knowledge that there was some type of trust, but it fails, for example, because it had not been accepted, then in that case, I would say, in my humble opinion, because we know that there is some sort of trust that has failed, then it will be a resulting trust that will go back to the testator's estate, I do believe. Let me know. I'm 99.9%. It's essentially based on the knowledge of the proposed secret trustee, and that there was going to be a secret trust or even a half secret trust then. Another example of failure in trust would be the government. No, would be where the example, the UK and the USG. It would be where, for example, the secret trustee dies before the testator dies. What? That can happen. So big look at that. All right. There's another little. Don't have to give you this. I give it you because I love you. I want to show you. All right. You got to show me love though, just like Robin S said. Heartbreaks and promises. So let's go back and rewind because that's important. Slow it down, rewind, selector. Another example of failure in a trust. This is quite a tragic example as well. So this would be really, really silly to make. This is basic 101, but I'm going to say it because, you know, it needs saying. It would be where, for example, the secret trustee dies before the testator dies. And in that particular situation, there would be a resulting trust going back to the estate. It can only go one way. All right. It can go back to Moo Moo land. Although some effect would be given to a half secret trust, although that is going to be a little bit more difficult because you don't really know what the intention of the original testator is in that situation. So moving on, the evidence can be problematic in this area as well. There's something called the parole evidence rule. On this, it prioritizes the written evidence over oral evidence. Would you believe? Yes. And you can imagine in the area of wills where you have a clear written identifiable document, authorized, it's legal document as well, okay, that is normally that would take precedent over any sort of oral evidence claim of a trust, and say that that as I know and I will tell you will be really difficult. And it's something personal happened to me with a trust. I'm not going to tell you, but I ended up losing out on 25 large from my dear grandmother Jean, bless her, and my granddad Arthur. So I know firsthand about this and what happened in my family and how I went from being a named beneficiary for 25 large to getting a sovereign coin and something on a chain because the 25 large, and my nan, when I was little, she gave me a sovereign coin, everyone. When I was about 12, I was fascinated with coins, threepenny bits, half pennies. Pause, everyone, break time. And these pennies that weren't circular, they were like octagon shapes and everything. They had holes in them, D's on them, old coins, crowns, half crowns, all this, old paper notes and stuff, big fivers, old pound notes. I was half pennies. I was the coin master. Back then in 84, 83, well, I was 78 born, so I was about 4, 6 years old, and I was into it. And sovereign came my way, mate, at that age, and she says you can have this, and I'm not here. I was fascinated with it, and look what we're looking at now. Hey, the sovereign. So my grandma, when I was 6 to 8, up to maximum of 12, knew, and she bestowed a sovereign on me from 1800s as well, minted in a special minting place. It's worth an extra bit of amount because it's a rare one. It's not getting sold. Pawned, it's collected, it's in the trust. So it's really, I can't argue things and stuff about it's horrible at that point in time where someone's passed and there's a deceased and you're arguing about estates and money and having to fork out bills, and you should be celebrating the life of the one that's passed, giving love, getting out there and benefiting from everything and receiving the energy that they've left, and moving on and enriching and enforcing, reinforcing our estates and lineages and bloodlines, and celebrating, and it's turned into a nasty, horrible. Incidentally, I hear that now the government of the UK will allow the burial of our sons and daughters for free now, having to fork out and having no estate, and even worse, a little loved one burial, as we've seen too many times, too often, and having to scrimp and scrape for that makes me want to be sick physically. The poor mums and the families that have had to do that, I feel like crying, in my heart. So if you feel like that, then well, thank you. You feel what's going on. So It's not nice. This is a horrible subject. So you make plans and you protect your loved ones so they don't have to go through this. They don't have to argue. They don't have to fight. You've made plans. You've made allowances. You've authorised. You've protected. Whether it be from creditors or not, this is about the family side of it, the private side of it, what's going on in the future. All right, thinking on, going from the now to the then. Nunc pro tunc, est nunc pro tunc, now for then. Latin. It's not a hard and fast rule. Sometimes we'll look beyond all of this. All right. So if there's not paper versions and you go in when you want to argue these secret trusts, then it's not a hard and fast rule. It's not set in stone. Equity trust. You have to go down it acts in personam. So the three certainties, the objections there. You can see that that creates a really difficult hurdle, a barrier that can be quite difficult to jump over. It's the standard proof in these types of cases, as per Lord Westbury in McCormick and Grogan. The requirement is the clearest and most indisputable evidence. And the reason for that high burden of proof is because you're alleging fraud in this situation. You're saying a beneficiary from the will is not the rightful owner of the property, and it should actually, be a secret trustee here, and then that will be giving it to somebody else. So, because the claimant is alleging fraud on the part of the defendant, that's why we have this high. As far as I can see, quote me if I'm wrong, it's very, very, murky, shark-infested waters. This, indeed, but I'll bring you what I found. Finally, the other thing that we need to talk about, it helps me, explore the flexibility of equity, the maxims there against the common law, of which you love so much, and you want to leave. You're all loving the common law. So if I help show you some of the versatility and the dexterity and the honourability, even in the face of such things as fraud, with a will, with secret trustees and beneficiaries and that, I can only say, wow. Just when you thought you knew it all, something like this gets brought to you, and you go, "Oh, a tube's gonna love this." What else do we need to talk about? Very briefly, joint ownership. Now that I've got a chart to give you, yeah, it's going to be a little bit difficult to understand without that, but hopefully I'll make it fairly simple. Essentially, very similar to the chat we had at the start. So instead of having a single intermediary, we have two. We have A and B, who are joint owners of a particular piece of property under a secret trust. And the problem is, in this area, is that A knows about and has presumably accepted the secret trust, but B, who is still a joint owner of the property, doesn't know about the secret trust. And so the problem is, what happens in this particular situation with respect to the intended beneficiary, which is C. And the question basically comes down to, when did A accept the position of being a secret trustee? What point in time? If they accepted before the will is made, then both A and B are bound by the secret trust. However, if A accepted after the will is made, then it's only A who is bound by it, and B would be a rightful beneficiary under the will. These are crazy questions. They're quite high level. You're not supposed to follow them. This is just to let you know what we know, where we are, what we've got. And these are notes that have been collated from my due diligence research, and I've tried to give you all of the case law and where we've found it, what we've done. This is the beauty of buying books and doing research. Shadow, John, Barry, all of those that have got many, lawful encyclopedias now. This is what the beauty of that does. Time, hour. When I talk about compensation, you need compensation for doing all of this, because it's thousands of man hours, not all mine, a collective, a continuum, which is here, the clean hands with me giving it to the tube, back, bounce it, take it, collect it, and come back, have a chat. I'm excited about the comments. I have to get the Queen, but I'm not yet. We've got time. So I'm going to finish here, I think. This is kind of a double-edged sword. On the one hand, this is a relatively simple area, and it means that it's quite self-contained in the terms of what you actually need to do and look at and study. On the other hand, this is quite a limited area of potential options, and so your ability to actually study and get a great degree of knowledge across the whole of equity and trust is somewhat limited. But this situation in itself and these trusts just made my brain pop at 2 o'clock the other morning, and I needed to sleep, and I went, why, universe, did you give me secret trusts at 2:10? of a whatever morn, and I was already doing the 100-page document and into bits and bobs. It was just a bit of synchronicity, I think, that my searching of the files brought up my notes on secret trust, Intestacy, and you might find that you're going to have to get to do a lot more research to get some higher understanding of this. We will help. Nevertheless, this is a complex problem, but simpler problem, but a complex one from the initial outset. You will need to go through the different requirements of intention, communication, and acceptance. That's where I'll leave you. And also consider the relevant issues that come up in relation to the problems, the scenario that I've, the presentation, lecture, whatever. The secret and half-secret trusts, such as intestacy, for example. Consider the role of secret trusts within these areas of law. Are they fair? Tube, I want an answer before we go. Is what I've just explained to you fair? Should the courts and the monarchy and the establishment, etc., lords, allow them to continue after I'm outing them? To be fair, I don't know many channels, not many like me in the Anglican and Britite landmass doing this, so please make sure you maximise on this and give it to all that would be interested in it and could utilise it without further ado. Should we stick to the formality set out in the Wills Act of 1837 1837 CE, year of our Lord? Thank you. How do you like them apples, eh? Who do you love? And who loves you? Yes, you're all accused of being in league with the devil. Well, if you're in these secret trusts and you promote and publicise this, you made this up primarily going back a long time, when ladies, you didn't always have the rights, all right? Let's go back there. What were they called? The ladies, don't tell me. The suffragettes and other such, burning the bra, they only wanted your tax money, ladies. What they did is they created, women, you need to stop being a family member. You need to stop nursing the babies and the offspring, the assets, get off the teat, get them into the indoctrination camps for one. That sorts out the agenda. We'll get them programmed. You can stop being a mother at the home and you get your arse to work, and we can call it independence and equality. Yes, that's what we'll call it. And we'll get your tax money, we'll get your levies, fines and charges. The family unit will be weaker, Mr. Speaker, and we will, it's an excellent idea. More money, more revenue, weakening of the family unit. Dark and shady time. So that's my opinion. That's not facts, all right? That's what I see. The structure of the secular, civil, codified area. Man is not person. We created government. I said this 3 years ago, minimum. And government created persons. We have the international covenants, all right? They're international in the covenants, but they're not part of the David Christian name given covenant original creator. I have, furthermore, another presentation that's very deep along this line, but going into history and land. There is Land Ahoy. If you see my Land Ahoy post, this is going down to the Land Charges Registrar, not the Land Registry, other such things. Land registration. 1925. We're going to go to the Doomsday Book. I mentioned this 2 years ago of tenure, land tenure, and certain things there. Doing this 100-page document has brought some amazing slap in the face moments to me. Skimming in the region of about 2,000 documents and looking at titles and annexes and whatnot, I found some stuff that I'd forgotten I had. On a 10-year journey, year 1 and 2 seemed to be a bit foggy. So what I've done is I said hello to 1 and 2 again. And in them years, I got some real golden nuggets that overwhelmed and was too perplexing for me. Like this here, this was where that was from. So now I thought, we'll do some research, and I've got some references. Met Richard Ansar, some other talkers, Santos Bonacci, been to some meetings, bought some books, done some seminars, and what do you know? What do you know? You know everything. You know what I know. I know that you know. So here we are. Honour, pleasure, privilege. Go get them. My self-initiates. That's how it works. I'm going to scroll. I'll go from the top, and then we're off. Coin, fly, Jerry. Fly. Albert, hello. Barnstar. Yes, much love to you. Easy, my brother. Thank you. Much love. Yes, all tones we used to. Yes, speaker, do you? Who do you love? And who loves you? I wasn't comparing myself to the Messiah. No, not at all. I'm just David. I'm a humble messenger. All right, I'm just a messenger, an alpha, a go-go, whatever you want to call it. But the covenant is original with me, and I stick to that. I'm aware of it, and I've been instructed, not like the presidents that reigned war and terror. I believe God wants me to go and free them by dropping bombs of terror and Moabs. No, I just mean that I've had some synchronicities that say I'm on the right track. So thank you for that, Jerry. I am not the Messiah. I am just a simple brother, and I like to share. These publications will be given to you. Hold tight, don't worry. Easy, I see John there. Quinn. If we hold our own trust deed on paper, does that not mean we hold our own court, as the court is the paper document? I've just explained to you what's going on there. If you want to complicate it and go into that, then we can do later. But right now, Quinn, good question. You see, are you in a court? I'm in a court now. I'm in a church now. I'm being monitored. As God as my witness, the Creator, Lord Almighty above. Was it to what in this world now? I hope things are becoming a bit more clear after these video presentations. I did bear you in mind yesterday with the self-initiate's introduction to trust and equity, when he asked me about the Christian side of things, God, Jesus, and what I say, Jesus being a historical conceptualization on the crucifixion. So it is quite irrelevant. So that's the court, that's the witness side of it. Yes, we are in a court. Is a bit of paper a court? Well, it's an instrument. It's an instrument. It's even a legal instrument, or it's a lawful instrument. Instrumentations, courts, that's an opinion of which I'm not really going to answer after what I've just done in the state that I'm in. I can't do that effectively. It's a statement of facts. It's evidentiary. It's an intent. It's a motion, an act, caught down, an intent, an expression, a deed. So it's many things. And what was your question? You had a trust deed on paper. Yeah, and that deed is a title, all right? A trust deed is a title. Come on, David. Title deed. If you've got the title deed, that means that you are the one that can claim until you pass, because we can't actually truly own anything, because you can't take it with you. With all of this trust and assets and property being talked about, remember, all right, I've told you in Smithy As, we've gone over this many times about the ownership, all right? It's not a good thing to have. And we see it differently. So you've got the title deed. That is not a court, really. No, it's a document, an instrument that's private, that says you have got the rights to property. That's not a court, in my opinion. There you go. We can talk about that, and I'm not saying you're wrong. I said that's my opinion, Brother Quinn. Premise, can't we have our own posts? And oh wow, moving on. My brain's hurting. I'm having a break. Remember, this is my day off. All right. I'm having a chill after this. I've had listen to this as well. When I give thanks and love today through you all and do this, I've had a flat tire on the horsey. A hoof is needed reshoeving. I've had the cab blower underneath the passenger footwell has gone. Smells of burnt sparklers in there today when I took the Queen to down the road on the A38, and it turns out the cab blower's gone. And the printer downstairs, if you need spares and repairs for a Canon Maxify MB 2050, it's 4 years old, everything works except the print error code, so the printer, the horsey, the fan blower, the flat tire. Getting an email from an international supermarket chain, Fiddle, telling me that I'm not good enough to scan on the shopping till front there as a chief cashier teller. It's been a crazy old weird somber week, so I'm tired. I want to rest. It's been hard at it, and I give love and thanks. All right. It's not bad luck. It's not negative. Change. That's all it is. All right. I embrace it. All right, Jerry. Watch back. Super chat. Bless you. Stop it. You're too generous. I say you're too generous. We love the super chat. If you would like to donate to me, other than what in this world, and it never happened. I've got a couple of regular, very generous super chat subscribers there. Thank you, much love, blessings. You go to the homepage of splspro.com, splspro.com, and there's a donate button on the homepage there. You would just put a message and a donation there, and I would then email you back and say I'd received it, just received it, thank you, much love, etc., and possibly add you to a mailing list, or you can, obviously have the option to chat to me externally if you're not a member on the .com and you just want to be a benefactor for the good times that we're having. I need help, or I don't want to go back and scan items of your cyclical consumption for grocery items. It's an international supermarket chain, 8 hours a day, 9 to 5, when I can be doing other effective, utilizing things and helping out. So that's my desire. Universe, it's with you, the tube, sharing, fam. I'm doing this for a reason, many reasons, okay? So thank you for the super chat. It does help. You are a legend. Much appreciated, and thank you for all the donations that are to come in, that have come in, and the support, the shares. We're going to speak later, Fly. All right, I have a busy day, but we'll chat. Don't you worry. And I'm off the clock then. There's no more chirp for me today. Wow, John, 13, 9 of you. That's getting better. Thank you for the thumb up. That's what's needed. Let them know you are happy. Great vid, Dave. Oh, Quinn, if I get a great vid from you, I know that you're one of the more connoisseurs of the scribes. You've got an intellect. I feel it. I see it. I have felt it. And that means a lot to me. I take that with honour. I am humbled. I am not trust master. I am not trust expert. I am your brother David, all right? You can take stuff from me and get it double checked, triple checked. That's what I'm here for. I'll speak to you in soft speak as an initiate of the Hermeticism and the principles. I consider myself a Christ-like entity, the ambassador. I work with the Par Star, the Ra Star, the Mini Star, Sovereign Smithy. When I say work with, privately, for the covenant of, and we've got nothing but love. That man has taught me so much. Smithy, I love you too much, brother. Too much. Nothing but good vibes for that man and his fam. You lot, good vibes. Remember that sonic boom of a phonetical quantum level that's been sent while we're chatting. My heart is glowing. I'm like the ready brick man of karma and vibration. And if you trust me, I'll trust you. That's how it is. Our only true currency. And as for these secret trusts, when you thought, you was getting ready and you thought you were getting somewhere, I just thought I'd let you know there's more. It goes deeper, all right, into the realm of the deep state secrets of the pale stale mail. New trust technology brought to you from the Romans and the pilots of Pontius. Before that, we've got the Mesopotamia. I can't wait for the Numa Elish. I have got such a little story and passage for you. I'm sorry for my randomness, and I'm very happy. I'm very honoured. I'm very blessed. Much love to all of you. I've said your names. You know who you are. And so the new initiates, welcome. Thank you. Get ready. This is the armour. The armour is being put on. It's not violent. There's no metal. It's invisible. This is the best armour that you can get. It's mental armour. All right? Armour for the mind. Amore. Grazie, bella, bella. Bello, bello. No mozzarella. Ciao, bello. See you later. Stay mellow. I'm a poet and I don't even know it. Good luck. Good loves. Goodbye. Create your own rap song on this. I used to be a DJ. It's relevant, sorry, the musical, what's that? Yeah, reach out and touch faith. The day I woke up with that in my head, I thought, I've never DJ'd that, It's speaking to me. Maybe it's a subconscious. Those of you that are trying to attack, I see you. We have many, many layers of protection. We are suffering weekly thousands of attacks. I am the account. If I ever disappear, it's because someone's been successful. We have Ukraine, Russia, the United Arab Emirates, China, Brazil, Mexico, everywhere, IP-wise. I know they're spoofed. We have lots of securities everywhere. It is frustrating. I am unable to be as instant and active as I used to, and we are looking at more security. This security for you is the homeland security. All right, look at us as oh wow, not really as in that way, as in a Babel type way, as a chief of staff. All right, I'm here with the staff. I've got my stick and it's full of paper scrolls. I'm giving them away, all right, to some extent. And the master of the rolls is maybe going to receive the scrolls at some point, and maybe the Vatican are, maybe the crown, in all forms, the 3 tripart forms. I've asked to join up. I'm doing it on my own, all right, effectively, not on my own. I've got you, I've got the .com, I've got the Book of Faces, if and when, but I have no study partner. I've been in this a while. I've been chewed up and spat out. I have got some good solids, like I've mentioned, and you know the names. The rest I give thanks for. I love you all. I have no hate, malice. I've changed and I've developed for the better. So you know, it's been a pleasure and a privilege. This has cracked my Swede, though. I won't pretend that this has been anything easy to outlay. I will check it for mistakes, as I suggest you do. I get giddy and excited, and as dyslexia, you know, it makes a word change before my eye, and it looks one way, and then if I go back and read it later or I hear it back, I will clearly see the difference and the mistake. So I apologise for that. I have a gift in one way, and I have an error with that gift in another, but that's good because you need to double check diligence. All right, no liability from me, only from those that are licensed and bonded. All right, so much love, thank you, ciao, and there is more to come. Keep up, put your seatbelts on. In effect, metaphorically, you singing home. I do, John. I do. Much love, and see you later. Thank you.